Greetings and welcome to Summary Judgment, Part 12, Order and Judgment. This brings us to the final segment of Summary Judgment, which we will have completed the entire volume from American Jurisprudence on Summary Judgment. That said, welcome to everyone, and just as a reminder, this is strictly for the educational entertainment purposes of this YouTube channel broadcast, not to be used, misconstrued, or abused for anything personal, private, legal, lawful, financial, tax, business, or otherwise, so please don't do this at home. That said, let's get started. We left off last time with section 58, and this brings us to a new chapter here for scope of relief, order and judgment in general. So, of course, order and judgment is going to be the relief for the summary judgment. So, summary judgment orders may be granted or denied in whole or in part, with specific requirements for formal entry and applicability of Federal Rule of Civil Procedure 54C. So, summary judgment may be granted or denied in whole or in part, depending on applicable statutes and rules. So, depending on the jurisdiction there's certain local rules that might apply to whole or part granting of the summary judgment. A formal order is usually entered, and both order and judgment are better practice when motion is granted. So both order and judgment are better practice when the motion is granted. So when they grant the motion, there should also be the formal order and judgment for the better practice. Order to dismiss complaint may be considered summary judgment if based on testimony and stipulated facts. Again, no dispute of facts here. And the Federal Rule of Civil Procedure 54C applies to summary judgments granting relief, even if not demanded. So according to the rule, now if we want, we could jump over here. I believe we have, not too sure if we have Federal Rule of Procedure handy here, but let me see if we do. I think we had it here. Let me just check here real quick. No, that's not it there. Nope, that's not it. All right, give me a second here, and we will get it up because I believe that we should have that rule handy for us. 1 second here. If you just arrived, please hit the like while we're doing all this nonsense here. This way we can get a, yeah, here we go. All right, so we're looking for the Federal Rules of Civil Procedure. Here it is. Okay. All right, so we have, this is from a previous episode that we did here, but this will bring us to 54C, so we can see it cited exactly. So here's 54C1, supporting factual positions or requirements, and I believe we were looking for, what did it say here? Just 54C. It didn't give us any of the sub numbers there. Let's get back to this. All right, so we have for 56, did it say 56 or 54? Oh, Lord. Yeah, we're at 54, so we're on 56, we're on the wrong one. Let's see here. Oh, I don't have 54 handy, so nevertheless, we'll edit this part out. Back to the book here. All right. So we have Federal Rule of Civil Procedure applies to summary judgments granting relief even if not demanded. And we have a caution here that the trial court does not have to explicitly set forth findings and conclusions to support its decision on a summary judgment motion, although such findings are helpful to the reviewing court. In fact, findings of fact in summary judgment orders are specifically discouraged to the extent that they create the impression that issues of fact were actually in dispute. Wow, that's an interesting one there too. So this is an interesting caution here. So let's see. how many people are here in the chat? If you could just pipe up in there and let me know, because I'm not sure the notifications went out. I don't see anyone in the room here. And we do have a special surprise at the end, so we need some audience participation for that. If not, I'll just reset the stream here and get some notifications to go out for the next one.
Craig Curry G5E says, I was notified. Craig Curry G5E says, I think you are muted.
Thank you. Indeed, that's true. All right. Good thing for the talking chat there. At least it wasn't muted. As I was saying here, the caution we have here is that a trial court does not have to explicitly set forth findings and conclusions to support its decision on a summary judgment motion. Although such findings are helpful, so we're talking about findings of fact and conclusions of law. Okay, although such findings are helpful to the reviewing court, this is if it goes to appeal. In fact, findings of fact in summary judgment orders are specifically discouraged. Why would findings of fact in summary judgment orders be discouraged? To the extent they create the impression that issues of fact were actually in dispute, meaning that it should have been denied. So by issuing findings of fact and conclusions, it creates the impression that perhaps it was made in error, the summary judgment. So again, the reviewing court will find it helpful. Sure, it will find it helpful because it may find that issues of fact were actually in dispute. All right, let's move along here. And we get to section 58 still, generally. Now let's go over some of the cases. The improper conversion of motion. A district court should not have converted the employer's alternative motion for summary judgment into motion brought by union without notice to parties. And error from conversion was harmful. Wow. So converting alternative motion for summary judgment into a motion brought by union without notice to parties. That looks pretty complex there. From the 7th Circuit 2003 with R.J. Corman Derailment Services, yikes, versus International Union of Operating Engineers. Then we have the timeliness of a motion to amend. The plaintiff's motion to alter or amend summary judgment entered in favor of defendant, which was not filed within 10 days of the summary judgment order, was properly converted into one for relief from final judgment. So here's the timeliness of a motion to amend. Was not filed within the 10 days of the summary judgment order, was properly converted into one for relief from final judgment. That's interesting there. So the plaintiff's motion to alter or amend the summary judgment entered in favor of the defendant, which was properly converted into one for relief from final judgment. Wow. It's Allender versus Raytheon, 10th Circuit 2006. And we're on to the review of summary judgment. So now let's see what happens when it goes to a reviewing court, an appeals court. When reviewing a diversity action, diversity in the different jurisdictions, right? You have maybe federal and state. A court of appeals looks to state substantive law, but follows federal law in determining the propriety of the district court's grant of summary judgment. Wow. So, diversity action, you get an action with both state and federal actions here. The Court of Appeals, if it's in appeals, looks to state substantive law, but follows federal law in determining the propriety of the district court's grant. Wow, the propriety of it, according to federal law. So again, the Federal Rules of Civil Procedure guiding how it's done, and then more of the details would be from the state substantive law. And that's Ring versus Lexington Apartments and Motor Inns, Oklahoma, 10th Circuit, 2001. Now we have a standard of review. District Court's denial of motion for summary judgment is reviewed de novo, viewing record and drawing all reasonable inferences in light most favorable to who? The non-moving party, as always. So the District Court's denial of a motion for summary judgment is reviewed de novo, meaning the record, everything in the record is reviewed again from the start as new from the appeals court here, viewing the record and drawing all reasonable inferences in light most favorable to the non-moving party. That's Maccabee versus City of Fort Payne, 11th Circuit, 2003. All right, now on to the reconsideration of summary judgment. Reconsideration of summary judgment is appropriate if there has been a mistake of law or fact. So a reconsideration is appropriate. That's from Demos versus City of Indianapolis, and that's 2001. Then the timeliness of reconsideration motion. A plaintiff's motion for reconsideration was not made within reasonable time, as it was made over 3.5 months after earlier order granted summary judgment. Boy, that's waiting some time. 3.5 months? Over 3.5 months. That's Siemens Westinghouse Power Corporation versus Dick Corp in Southern District of New York, 2004. All right, now we're on to the issues of material fact. A genuine issue of material fact with respect to extent of illegal conduct engaged in by provider of insurance claim services. Illegal conduct? Oh boy. Owners of insured HUD partnership properties and their officers and agents, when such illegal conduct began and ended, whether such illegal conduct affected legitimacy of services provided by the parties, and what exact relationship between the parties was precluded summary judgment. Gee, sounds pretty complicated. From the Meadowbrook Richmond versus Associated Financial Corporation, of course, New York, 2003. And now we have the forfeiture of defense. Ambulance manufacturer forfeited its just cause defense at summary judgment stage of distributor's action against manufacturing alleging violations of Puerto Rico Dealers Act, where manufacturer did not include the defense in its summary judgment motion. So there's a just cause defense at the summary judgment stage of a distributor's action. And the manufacturer forfeited it because did not include the defense in its summary judgment motion. Wow. That's Re-Ace Incorporated versus Wheeled Coach Industries in Puerto Rico, 2005. So the ambulance manufacturer had forfeited the just cause defense at summary judgment stage of the distributor's action against manufacturer, where so it's a distributor against the manufacturer here, where the manufacturer did not include the defense in its summary judgment motion. So they had what kind of all right, summary judgment of distributors. Oh, okay, the action was against it, and then they tried the summary judgment to, I see here, did not include the defense in its summary judgment motion. Okay. I see. All right. So, words of the wise include that your defense in that summary judgment motion stage as well, so you're not forfeiting it. Effective voluntary withdrawal of appeal. Plaintiff's voluntary withdrawal of her appeal of district court's decision to award summary judgment to defendant barred her from motion for reconsideration of the court's decision. So that's Sherman versus Verizon, Virginia, and dismissed in part. This is 2003. That seems like a pretty complicated case there, especially with a voluntary withdrawal. Now we have a reporter's record in summary judgment. Creating a reporter's record is a practice neither necessary nor appropriate to the purpose of a summary judgment hearing. Creating a reporter's record is neither necessary or appropriate. And that's from Schneider, National Carriers versus Bates in Texas 2004. Moving right along. We're on to section 59 now, the time of entry of judgment. The timing of summary judgment entry depends on statutory or court rules, so our local rules now for timing, particularly regarding whether a plaintiff may move for summary judgment before the defendant has answered. So you have the action, the pleadings are filed, served. It has to be time for an answer from the defendant before moving for summary judgment. The propriety of entering summary judgment for plaintiff before defendant answers depends on statutes or rules of court. Under Federal Rule of Civil Procedure 56, which we did have on screen earlier, plaintiff's motion for summary judgment should not be granted before answer unless clear that answer cannot raise issue of material fact. Unless it's clear, that seems like a high bar there. Some courts uphold plaintiff's motion before answer when finding no genuine issue of fact, despite possibility of new facts in answer. Then courts generally are reluctant to grant a plaintiff's motion before an answer, though. So let's see how some of these cases pan out when the rubber meets the road. Well, maybe not. So let's just review this one more time because we're going to go on to the next section. So the time of entry under the Federal Rule of Civil Procedures, it should not be granted before, unless it's clear that the answer cannot raise issue of material fact. So there's your clear exception there. But some courts hold that plaintiff's motion before answer when finding no genuine issue of fact, despite the possibility of new facts in the answers. We saw the affidavits, things like that could bring in new facts. But it could still be, it seems like it could still, the motion could still be filed. It'd still be, but again, it seems like it's generally a reluctant to grant a motion before the answer. So it seems like not a good practice in general. All right, we're on to section 60 now, before completion of discovery. The timing of summary judgment in relation to discovery completion varies, with some courts requiring discovery before granting summary judgment, while others follow Federal Rule of Civil Procedure 56F for parties needing more time to conduct discovery. So I guess we could do this right now. We could jump over here to F and see what let's see here. Here we go. F, judgment independent of the motion. After notice and reasonable time to respond. There's our reasonable time. This is all it's going to state. So the court may grant the summary judgment for the non-movement, grant on unraised grounds, or consider on its own. Reasonable time to respond, though. And then, so that's 56F. All right, let's get back to where we left off here. All right, so we see here that while others follow this for parties needing more time to conduct discovery, so reasonable time, a summary judgment normally should not be granted before discovery is completed. Some discovery must be afforded to the non-movement before a summary judgment is granted. Federal Rule of Civil Procedure does not require that any discovery take place before a motion for summary judgment can be granted. So it doesn't require that any discovery actually takes place. And then if a party cannot adequately defend against summary judgment because of insufficient time for discovery, Federal Rule Civil Procedure 56F is the proper remedy. So reasonable time, and let's see what it said here. Yep, grant summary judgment for the non-movement. Grant on unraised grounds or consider on its own. So there it is. Let's move along. So Section 60, before the completion of discovery continued, we have discovery required before the summary judgment. Here's a case where it was required. The district court erred in granting summary judgment against commercial publisher on claim challenging Defense Department's in-house maintenance of Internet accessible database for dissemination of government documents without first giving publisher opportunity to conduct discovery to determine whether private contractors were already performing or had already been asked to perform work in question. Ooh boy. And that's Information Handling Services versus Defense Automated Printing Services. DC Circuit 2003. So it erred in granting a summary judgment to district court against a commercial publisher on claim challenging the Defense Department's in-house maintenance of Internet for dissemination without first giving in-house maintenance of Internet accessible database. Whether probably we're already performing. Wow, that seems like a conflict there. Okay, now we have the discovery stay not warranted in class action. Stay of discovery pending resolution of summary judgment motion was not warranted in proposed class action brought by patrons of restaurant whose employee had been diagnosed with hepatitis A. Oh boy, you got hepatitis. Seeking damages for physical pain, physical symptoms, and fear and emotional distress arising from trauma associated with contracting the disease. It's a stay of discovery pending resolution of summary judgment motion was not warranted. Okay, so no stay for the summary judgment. They get to have that discovery brought by patrons of restaurant. That's Evans versus Yum Brands. Oh, yikes. 2004. That doesn't sound too yum to me. Physical symptoms, fear and emotional distress rising from trauma associated with contracting the disease. Patrons of the restaurant. Yikes. All right, that's pretty creepy. Let's move along here. I tell you, this stuff in real life is better than any kind of scripted drama. Here we go. Section 61, entry of judgment for opponent. Courts may render judgment for the opposing party, even when that party has not moved for summary judgment, though this authority varies by jurisdiction and statutory framework. So, some jurisdictions specifically authorize courts to render judgment for opposing party upon motion by one party. Wow. Specifically authorize the courts to render that. And in jurisdictions without specific statutes, courts have both upheld and denied this power. So unless there's specific statutes, it's up for grabs. And under Federal Rule Civil Procedure 56, the court may grant summary judgment in favor of a party that did not request it, as we saw here. Grant for summary judgment for non-movement here, and so there you go. And then we have the proper notice to adverse party is required when granting judgment to non-moving party. So you got to let the other party know, hey, we're granted to the other party. Sorry about that. A judgment for the opposing party without cross motion. So no cross motion, but they still granted for that other party. Summary judgment may be rendered in favor of opposing party, even though he has made no formal cross motion for summary judgment, if undisputed facts are found which, when applied to the law, indicate that judgment against the moving party is inappropriate. That's Sunderland versus First Reliance Standard Life Insurance, New York, 2002. And that takes to Section 62, the effect of judgment or order. Reconsideration. So this is a big one here that we were reading about earlier, about the reconsideration. Summary judgment determinations have specific effects on appealability, as we're seeing here with the reviewing court and reconsidering, making it difficult without findings of fact, right? So summary judgment determinations have specific effects on appealability and subsequent proceedings, with particular rules governing reconsideration motions based on new evidence. So the summary judgment determination is as final as a determination after trial on uncontroverted facts. The order granting summary judgment is appealable as a final decision, at least if granted on the whole case. Denial of summary judgment is an interlocutory decision only, not directly appealable. So the denial of it is not appealable. And denial of is interlocutory decision. Wow, okay. So denial of summary judgment merely determines that a fact issue is involved. It does not establish law of the case. So this seems a lot different than like a...
E. Carolini says hello from Maine, USA, arriving late but saved the whole series to a playlist for study. I may need to draft one soon.
Excellent. I'm glad you made it in, and you'll be delighted that this one here is actually the last in the series. So once we finish here tonight, we have completed the entire series from American Jurisprudence volume on summary judgment. So we're just about there. Stay to the end, and we have a special surprise. So back to where we were here. That a denial of summary judgment merely determines that a fact issue is involved and does not establish law of the case. So this is quite different from a demur, where it's really about law. It assumes, even if the facts were true, that there's a no case in law. Now, a court's denial of summary judgment does not preclude a party from raising at trial any issues considered in summary judgment proceeding. So the denial doesn't bar any kind of raising of issues that were considered, maybe not appropriate for summary judgment purposes, but maybe for trial. As we saw before, there are things that could be admitted in summary judgment that would not be admitted in trial. Okay, so now we have our practice guide. A post-judgment motion to reconsider a summary judgment based on subsequently produced evidence is treated as a motion to alter or amend a judgment under Federal Rule of Procedure 59E. So a post-judgment motion to reconsider a summary judgment based on subsequently produced evidence. Wow, it's treated as a motion to alter or amend a judgment is what that would be. So it wouldn't be a reconsideration. It would be a motion to alter or amend the judgment. Okay, nice little practice tip there, should anyone be in that position. Which takes us to Section 62 with the cases here for the effect of the judgment or order with reconsideration. We have relief from summary judgment. The landowner was not entitled to relief from summary judgment granted to town officials and adjacent landowner on his claims challenging issuance and enforcement of adjacent landowner's special use permit on grounds that defendants misrepresented nature of adjacent landowner's activities, inasmuch as argument was merely effort to relitigate the merits and did not present newly discovered evidence. Oh, wow. And alleged misrepresentation, even if incorrect, was not material because it did not alter the conclusion that the town and its officials retained discretion in enforcing town's zoning laws. So the matter of, wow, okay. So no relief from summary judgment in a reconsideration here, even though the new facts, they're merely an effort to relitigate the merits. It did not present newly discovered evidence. Rosendale versus Luliano, Second Circuit 2003. All right, let's move along here. The tolling of appeal period. 30-day period for filing notice of appeal was tolled when plaintiffs filed motion to correct clerical error within 10 business days after entry of summary judgment in their favor, and therefore defendant had 30 days from the date upon which the district court disposed of the motion to correct the clerical error to file timely notice of appeal. Within 10 business days after the entry of summary judgment in their favor. Therefore, defendant had 30 days from the date upon which the district court disposed the motion to correct clerical error to file timely notice of appeal. Wow, that's a little confusing there. Within 10 business days after the entry. Oh, the 30 days, okay. Oh, looks like someone was really late in filing there. Dudley State here versus Penn America Insurance Corporation, 2002. Now we have the correction of judicial oversight, a motion in which judgment creditors requested district court to enter money judgment against judgment debtors' insurer, oh boy, was properly treated as motion to correct clerical mistake arising from judicial oversight, rather than motion to alter or amend judgment, inasmuch as amended judgment did not affect substantive rights, but rather merely corrected judicial oversight. So it's a motion in which judgment creditors requested district court to enter money judgment against judgment debtors' insurer was properly treated as a motion to correct a clerical mistake, rather than motion to alter. Wow. No substantive rights, but merely corrected judicial oversight. He forgot to enter in the money judgment. Okay. All right, same case, 2002. Let's move along. Now we're on to the scope of relief, order, and judgment. Complete or partial summary judgment. Limitation of issues.
Sorry, Stack says call me anything but late for dinner or untimely.
Well, greetings, better late than never. And it's a good thing because we're on the final episode here, and we're going to have a special surprise at the end, so make sure you stay to the end. Let's continue here. So this chapter here now, the scope of relief, order, and judgment. Now we're on the complete or partial summary judgment and the limitation of issues. Starting with generally, 63. Summary judgment may be complete or partial, with partial judgments addressing specific claims or issues while leaving others for trial. The distinction affects finality and appealability. We'll see why. Partial summary judgment differs from complete summary judgment as it cannot end a proceeding and is interlocutory. Complete summary judgment adjudicates all issues raised by pleadings and is final in nature. So under Federal Rule of Civil Procedure 56A and B, a party may move for summary judgment as to all or any part of a claim. Let's see if that's true. 56A and B. Hang on a second. Yeah, 56A. It's going to be at the beginning here. All right, so we have, let's see, 56A, the motion for summary judgment. A party may move for summary judgment identifying each claim or defense or the part of each claim or defense on which summary judgment is sought. So it could be identifying each claim. A court grants if no genuine dispute. Movement must be entitled to judgment as a matter of law, and court must state reasons, okay? And 56B, the time to file. Unless a different time is set by local rule or court orders otherwise, a party may file a motion for summary judgment at any time until 30 days after the close of all discovery. So that's our standard deadline. 30 days after all discovery closes. Local rules may establish a different time, as we saw before, and the court may order otherwise. So let's get back to our presentation here. All right, there we go. So, again, with our scope of relief here, that's Federal Rule of Procedure 56A and B, a party may move for summary judgment as to all or any part of the claim, as we saw. Federal Rule 56D requires a court to specify facts without substantial controversy. and direct further proceedings. And the court may grant partial summary judgment even if a party asks for a complete one. So the court may pick and choose out of that. So let's look at some of these cases here. A partial final judgment on attorney's fees. A summary judgment in favor of lender on its breach of contract claim against members of bankrupt LLC did not warrant entry of partial final judgment where lenders sought award of attorney's fees pursuant to parties' agreement. District Court had entered judgment in lender's favor based on representations and certificate executed by Corporate Assistant Secretary of LLC, but not on the basis of parties' agreement, and members contested lender's right to recover fees pursuant to agreement. So, looks like they have to, that's Chase Manhattan versus Iridium Africa Corporation in Delaware, 2004. All right, well, on to partial summary judgment on CAA violations. That's the Clean Air Act. The trial court did not decide issue outside of those presented for the court's determination when it granted a motion for partial summary judgment holding that retailers violated the Clean Air Act by selling or distributing pesticide for reptile ectoparasites containing a Class II substance. Motion requested court to hold that any sale or distribution of pesticide by retailers constituted a violation of CAA, and that if the court found that retailers did in fact sell or distribute pesticide, plaintiff requested court to grant summary judgment against the retailers. So this is an interesting one we read about earlier in the series. Was this Pound versus Aerosol Company in Kansas, 2004. But the trial court did not decide the issue outside of those presented for the court's determination when it granted the partial summary judgment holding that the retailers violated the Clean Air Act. And I believe there's something else with something about certain facts were undisputed as far as that the retailers know they were selling pesticide. It's whether they knew they were selling this Class II substance for reptile ectoparasites. All right, so it's very interesting to see the reptile ectoparasites enter American jurisprudence. Let's continue. Admission of uncontested facts. All right, if you guys are just arriving here, just to let you know, we do have the talking chat enabled, I believe. Let's double check here.
The tribe says, hit the like.
Yes, indeed, we do. So if you feel like you need to make a comment here or have something to add, definitely pipe up in the chat and be featured here as well as we can read it. Okay, so let's read some of these cases here. The admission of uncontested facts. So remember, affidavits including things like admissions, answers to interrogatories, depositions, and such, those are also materials that are considered for summary judgment. So here's admission of uncontested facts. Given the defendant's failure to present statement of disputed facts in response to movement's statement of uncontested facts submitted in support of motion for partial summary judgment, the statement of uncontested facts that would be deemed admitted and district court would consider only whether movement was entitled to partial summary judgment as a matter of law. So it's the defendant's failure to present a statement of disputed facts in response to the movement statement of uncontested facts in support of the motion for summary judgment, partial summary judgment. So they are going to admit the uncontested facts because the defendant didn't dispute them, and they would be considered for that only whether the move is entitled to the summary judgment now as a matter of law. The facts wouldn't, they're uncontested. Okay. Improper form of partial summary judgment. Plaintiff's motion for partial summary judgment on issues of damages was improper form, where facts and conclusions plaintiff wished to establish would not dispose of any of its claims entirely. That's from Evergreen International versus Marinex Construction, 2007. Now we have the finality of summary judgment. Now this would not be a partial one, I believe. Although a judgment following a trial on its merits is presumed, on its merit is presumed to be final, There is no such presumption of finality following a summary judgment or default judgment. So there's no presumption of finality. And even with a trial, it's only presumed final. Wow, now that's very interesting. And that comes from Burlington Coat Factory Warehouse of McAllen in Ray. So this is their bankruptcy here. Looks like Texas 2005. Let's move along. And we're on to 64. On part of single or multiple claims. Wow. On just part of one of those single or multiple claims. Courts may grant partial summary judgment on specific claims while leaving other claims for trial, with rules governing when such partial judgments may be entered as final judgments. Oh boy. So under federal rules and state rules patterned after them, partial summary judgment on separate and distinct claims is permissible. Federal Rule 54B gives trial court discretion to direct entry of final judgment upon one but fewer than all claims in a cause of action. So the courts have that discretion under the federal rules. Final judgment on fewer than all the claims requires express determination that there is no just reason for delay. So it has to be shown that there's no reason to that just bring it to trial. The delay wouldn't. That there has to be no reason for delaying. 54B applies to actions involving multiple claims or multiple parties. And the partial judgment on some claims allows parties to appeal those claims while litigation continues on the remaining issues. All right. There we go. 65, Section 65, judgment against less than all the parties. Oh boy, so the courts may grant summary judgment against specific parties while allowing a case to continue against others, provided remaining parties are not prejudiced by the partial judgment. Oh boy. So court may grant summary judgment against parties having no cause of action or defenses without granting judgment against parties as to whom an issue of fact exists. The plaintiff's inability to obtain summary judgment against all defendants does not preclude entry of summary judgment against some defendants. And the partial judgment is permissible if other defendants will not be prejudiced. So as long as it's not hurting the other ones from that. And under rules requiring answer before summary judgment, failure of one defendant to answer will not defeat summary judgment against a defendant who has answered. And the partial summary judgment is particularly appropriate when several liability is sought. So you're looking for liability from several parties, and the partial summary judgment is appropriate in some cases with that. Very interesting. Let's proceed. And we're on to section 66. This is our final section here. Judgment on sole issue of liability. Assessment of damages. Courts may grant summary judgment on the issue of liability alone, even when there is a genuine dispute about the amount of damages, allowing for liability determination to be separated from damages assessment. Wow. So under Federal Rule 56C and similar state rules, summary judgment may be rendered on liability alone despite genuine issues as to the amount of damages. Now let's see about that, because 56C, here we go, let's see here, supporting factual positions. So cite record materials, must cite particular parts of the material record. We've seen this one here. And method 2, show materials that don't establish dispute. Here we go, objection as not supported by admissible evidence. And we have materials not cited. What else we have here? Affidavits and declarations. That's it. So what were we referring to here now? In 56C, we have liability alone despite genuine issues as to the amount of damages. Okay, so it looks like opinions subject to cross-exam based on current knowledge must avoid hearsay without exception. Let's see here. May consider unsigned materials. Not supported by admissible evidence, hearsay, improper expert testimony. Supporting factual positions. Don't establish absence or present genuine dispute. Oh, okay, here we go. Show materials don't establish dispute. Show side materials don't establish the absence or presence of genuine dispute, or that adverse party cannot produce admissible evidence. So, yeah, I guess courts consider cited material, other materials. See about the liability here. 56 is what we said here, 56, right? Kind of odd. I'll have to look into this a little deeper here. 56C. And other similar state rules, and that's what we were just looking at, was 56C. So yeah, that's kind of interesting here, where it really, here's C4, personal knowledge. Yeah, that's it for 56C. I guess that's about it on that. Cite the record materials. All right, it seems kind of strange they're mentioning the liability here with section 56C and similar state rules. Summary judgment may be rendered on liability alone despite genuine issue as to the amount of damages. Plaintiff or claimant may be granted summary judgment subject only to determination of amount of damages. Summary judgment on liability alone is interlocutory in character. Okay, wow. And may be modified or vacated before final judgment. Wow, on liability alone. Summary judgment for plaintiff on liability may be set aside and summary judgment for defendant granted. And separating liability and damages issues allows for more efficient case management and potentially earlier settlement discussions. Oh, I see. So yeah, summary judgment for liability alone, and then the amount of damages can be litigated. All right, I get that. Let's move along now. This takes us to the end of our presentation and to the best part for those of you that have stayed to the end. You get to test your knowledge now on summary judgment by taking the summary judgment quiz. So it's a fun quiz here. Easy way to do this is just to answer in the chat. Put in the number of the question you're answering and the letter of your choice. So if you're doing for question 1, you were going to choose letter D. You would put in the chat 1 delta, and that would mean you're selecting the D for your answer. But let's read the questions now and give you guys time to answer in there. So let's start. Question 1. Under what circumstance may a court grant summary judgment against a party who has not moved for summary judgment? A. Never, as this would violate due process. B. Only with explicit statutory authority. C. Only if undisputed facts indicate judgment against the moving party is appropriate. Or D. Only if non-moving party has received proper notice. So is it A, never? What circumstances may a court grant summary judgment against a party who has not moved for summary judgment? So it's against.
Sorry, Stash says, capital D.
Only if non-moving party has received proper notice. You're picking, is that for D you're picking? You have to put the number of the question, so you get another chance for your final answer. So what circumstances may a court grant summary judgment against a party who has not moved for summary judgment? So let's see here. Never, as this would violate process. Only with explicit statutory authority. And only if undisputed fact indicates some judgment against the moving party is appropriate. Or D, only if the non-moving party has received proper notice. So it's against a party who has not moved for summary judgment. And now a court has granted summary judgment against them. All right, let's move on to question 2. What is the difference between a complete and a partial summary judgment? A, complete judgment resolves liability, partial resolves damages.
Sawyer's stash says.
Oh, yeah. Well, question 1, we'll just leave that there for now. Where'd that come from? All right. Oh, retracted. There we go. Okay, so granting summary judgment. So a party didn't move for summary judgment, and the court grants summary judgment against the party who has not moved. So a party has moved for summary judgment. It's granted against the non-moving party. When can that be done? All right. So now we're on to question 2 here. What's the difference between partial and complete summary judgment? Complete judgment resolves liability. Partial resolves damages. B, complete judgment is final. Partial is interlocutory, meaning in between the litigation. C, complete judgment requires full discovery. Partial does not. And D, complete judgment requires all parties to move. Partial does not. Okay, this should be very easy now. What is the difference between partial and complete summary judgment? So complete resolves liability, partial resolves damages. Or is it B, complete judgment is final, partial is interlocutory? Of course, final judgment is something that can be appealed. Interlocutory cannot, because it's not a finality of a case, is what they're saying here. And on C, complete judgment requires full discovery. Partial does not. Or D, complete judgment requires all parties to move. Partial does not. That's harkening back to our confusing question 1, but that's the hard one. So any answers for question 2, pipe up in the chat, and we're going to keep moving on to the questions 3. Question 2 should be easy, though. All right, let's move on to question 3. When may a plaintiff's motion for summary judgment be granted before the defendant has answered? A, never, as this would violate due process. B, only if no genuine issue of fact exists. C, only if discovery is complete. And D, only if the plaintiff has standing. So, when will the plaintiff's motion for summary judgment be granted before the defendant has answered? So, before it gets answered. Never, as it would violate due process. B, only if no genuine issue of fact exists. C, only if discovery is complete, which would be kind of difficult. This guy hasn't answered yet. Or D, only if the plaintiff has standing. So question 3, pretty easy one there. Someone can pipe up in there, put in your answer for question 3. And we're going to move on to question 4, but you can answer any of them at any time by just putting the number of the question and a letter of your choice. So question
4. G5E says 3B.
All right, 3B is your selection. Noted.
Sawyer's stash says 2 equals B, 3 equals A.
Oh, okay. 2 is B and 3 A. All right. So we got some good selections in here. And just to refresh our memories for question 2, for B, judgment is final, partial is interlocutory. If you've noticed a theme through all these 2B, or not 2B, but most of them have been 2B has been the correct answer on that. But we'll see at the end of this. Let's see if that's a harbinger. So question 3, when may a plaintiff's motion for summary judgment be granted before the defendant has answered? We had our answers on there. For 3, we had a B, and we had an A. Now we're on to the final question, question 4. What is the effect of a court's denial of a motion for summary judgment? A, it is immediately appealable as a final decision. B, it is an interlocutory decision only. C, it precludes raising those at trial, meaning it makes them impossible to raise at trial. Or D, it requires a new pleading. So what's the effect of a denial of a motion for summary judgment? Is it immediately appealable as a final decision, the denial? Is it an interlocutory decision only, meaning it doesn't bring finality to the case? Does it preclude raising those issues that were in the summary judgment at trial? Or D, does it require a new pleading? Any takers for question 4, our final question and the final one of this series? This should be an easy one. The effect of a denial of a motion for summary judgment. What is the effect of that? And as we remember, there's a couple effects we read about in there, and we have a very easy correct answer here for number 4. Any takers? We're going once, going twice. All right, we're going to go to the answer slide, and here it comes. All right, here's our answer.
Sorry, Stash says 4 equals C.
All right, just in time. Let's see.
Craig Curry G5E says for A.
Okay, so we have some answers here. So for question 1, under what circumstances may a court grant summary judgment against a party who has not moved? And it's C, only if undisputed facts indicate judgment against a moving party is appropriate. So summary judgment may be rendered in favor of an opposing party, even though they have made no formal cross motion, if undisputed facts are found which, when applied to the law, indicate that the judgment against a moving party is appropriate. And that was from section 61, the entry of judgment for opponent. Now we have on to question 2. What is the difference between a complete and partial summary judgment? And of course, B is the right answer. Complete judgment's final, partial is interlocutory. I believe we had some correct answers on that. And that, of course, that a partial summary judgment differs from a complete one is that it cannot end a proceeding and is therefore interlocutory, while a complete summary judgment adjudicates all issues raised by pleadings and is final. Of course, there's that presumption of finality isn't there, but it's considered final, as I guess, regarding appeals. And now it's from section 63. All right, we're on to question 3. When may a plaintiff's motion for summary judgment be granted before the defendant has answered? And of course, that was B, but only if no genuine issue of fact exists. It means there's really nothing to answer on. It's all decided in law. A plaintiff's motion for summary judgment should not be granted before an answer unless it is clear that an answer cannot raise an issue of material fact. But courts are generally reluctant to grant a plaintiff's motion before the answer. All right, and that takes us to the final question, number 4. What is the effect of a court's denial of a motion for summary judgment? And the answer was B. It's an interlocutory decision only. So the denial has no finality. The denial of a motion for summary judgment merely determines that a fact issue is involved and does not even establish the law of the case, making it an interlocutory decision only and therefore not directly appealable. And that was from section 62, the effective judgment or order and the reconsideration. All right. Well, that takes us to the end. That takes us to the end of this presentation in this whole series on summary judgment, condensed from American jurisprudence. This was our final episode here, part 12, as we went over the order and judgment. I'd like to thank you all that have attended here and participated. And I know there's a lot of things out there that are a little bit more exciting to do and more engaging perhaps, but I think where this the law and the rubber meets the road with these cases and in summary judgment, a very easy way to digest a lot of these cases here and see how they affect the jurisprudence, and also where this somewhat new device here of summary judgment, which we've learned only from the 1900s, is affecting a lot of the cases that we see now in the courts. So I think it behooves us all to have a better understanding of it. And salute to you all for being here and participating.
Sawyer Stash says, well done, the tribe. Gratitude.
And well, thank you. And thank you all for being here and making it feel purposeful to be doing this, and keep faith that we can keep our American jurisprudence alive. As I guess you could say, it is the best system in the world. I can't see when it's any better right now. And as long as we keep it alive, they'll be there for posterity too. So with that, I thank you all for attending, and I hope to see you on the next one. Peace out.